Hey everybody, this one is called Do-It-Yourself Kangaroo Courts number 16. It's about the 7 elements of jurisdiction. You know, I've actually used this. I put it into a demand to dismiss for failure to, well, we're going to talk about it. Anyways, it's worked a couple times so far. It's worked every time I've used it. First of all, I'm not a liar. Well, I meant a lawyer. No, I meant a liar. You should never take my word for anything. You should always do your own research. I provided references to aid you in your research, but I don't know everything, and I'm open to ideas. There's 4 types of people you'll meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people don't know their basic rights and freedoms, how can they know when or if their rights and freedoms are being infringed? Never forget the men who started this country were marijuana growing, whiskey drinking, tax evading rebels who left their beds at night to shoot at the pigs. It's true. All tyranny needs to gain a foothold is for people of good conscience to remain silent. So anyways, we're talking about jurisdiction. And there's 7 elements of jurisdiction. Lacking any of the 7 elements or portions thereof, unless you waive them intentionally or unintentionally, all designed to ensure against further prosecution, it is the defendant's duty to inform the court of facts alleged for determination of sufficiency to support conviction, should one be obtained. Otherwise, there is no lawful notice, and charge must be dismissed for failure to state an offense. Okay, and so there's your answer. Okay, it's a demand to dismiss for failure to state an offense. Without lawful notice, there is no personal jurisdiction, and all proceedings prior to filing of a proper trial document in compliance with the 7 elements is void. A lawful act is always legal, but many legal acts by governments are often unlawful. Most bureaucrats lack elementary knowledge and incentive to comply with the mandates of constitutional due process. They always deny due process. This says they'll make mistakes. They may be mistakes. Sometimes I think they do it on purpose. Numbers beyond count can have been convicted without benefit of governmental adherence to these 7 elements. You know, I've seen one indictment in Texas that might be a lawful indictment. And I've seen a bunch of them. They always deny due process. Always. Anyways, due process is only one of the elements of jurisdiction. There's a speedy trial for a misdemeanor is 60 days, a felony is 180 days. They almost always violate that stuff. They're fake indictments. They always deny due process in 100 different ways. And if you don't know what's going on, you're just going to wind up going and spending the rest of your life in Crowbar Hotel. The number 1 element of jurisdiction. The accused must be properly identified. Identified in such a fashion that there's no room for mistaken identity. The individual must be singled out from all others. Otherwise, anyone could be subject to arrest and trial without benefit of wrong party defense. Almost always, the means of identification is a person's proper name. But any means of identification is equally valid if said means differentiates the accused without doubt. There is no constitutionally valid requirement for you to identify yourself. That's the 4th Amendment. You don't have the right to give evidence against yourself, and you don't have a duty to give evidence against yourself, and you don't have a duty to let them have access to your papers. and a name, an address, a date of birth. That's all hearsay. And if they go and you give them one thing, okay, and they go pull it up in their hearsay database, you didn't introduce that evidence. Their database is full of hearsay evidence, and unless you introduce it, it is inadmissible. But that judge is sitting there playing stupid, and so you have to bring up the issue. The second element of jurisdiction, the statute of the offense, must be identified by its proper and common name. A number is insufficient. Today, a citizen may stand in jeopardy of criminal sanctions for alleged violation of statutes, regulations, or even low-level bureaucratic orders. Example, Colorado National Monument superintendent's orders regarding an unleashed dog or a dog defecating on a trail. If a number were to be deemed sufficient, government could bring new and different charges at any time by alleging clerical error. For any act to be triable as an offense, it must be declared to be a crime. Charges must negate any exception forming part of the statutory definition of an offense. By affirmative non-applicability, in other words, any charge must be affirmatively negate any exception found in the law. Again, they rarely do this stuff. In all the ones that I've done, they didn't satisfy any of these elements. Okay, when you start going in there, for example, the name. Okay, the first element, the name. That's a Roman cult sesticate trust. And they're pulling it out of their hearsay database in their computer system. That's all hearsay, and if you didn't introduce it, then it's inadmissible. The statute, same thing, okay? I had one where the clerk said, under penalty of perjury, that the cop said that I committed a crime. Or it wasn't even a crime, it was a Class C misdemeanor, okay? Well, talk about a bogus claim, okay? That clerk doesn't have first-hand knowledge of anything. They do this all the time. And unless you bring up the issue, they're going to steal your money. They're going to sell you into slavery. I mean, these people are nothing but a bunch of thieves and pirates. Element number 3. The acts of the alleged offense must be described in non-prejudicial language and detail so as to enable a person of average intelligence to understand the nature of the charge, to enable preparation of defense, the actual act or acts constituting the offense complained of. The charge must not be described by parroting the statute, not by the language of the same. The name of the acts, the naming of the acts of the offense describes a specific offense, whereas the verbiage of the statute describes only a general class of offense. Facts must be stated. Conclusions cannot be considered in determination of probable cause. Again, they never, well, I won't say they never do, but in my case, they never did. Anytime I use this, I made up a demand to dismiss for failure to state an offense, and I went through all the 7 elements of jurisdiction, and I said, and I listed this right here, and then I said, they haven't complied with it, and here's why. The facts, is it a crime? Okay, if it's a Class C misdemeanor in Texas, it's not a crime. Are you in the jurisdiction, federal areas? Are you a person? Okay, are you a U.S. citizen? These people they're all U.S. citizens imposing a territorial jurisdiction, martial law, in federal territories. Are you a U.S. citizen? Element number 4. The accuser must be named. He or she may be an officer or a third party, but some positively identifiable person, human being, must accuse. Some certain person must take responsibility for the making of the accusation, not an agency or institution. This is the only valid means by which a citizen may begin to face his accuser. Also, the injured party, corpus delicti, must make the accusation. Hearsay evidence may not be provided. Okay, anyone else testifying that they heard another party was injured does not qualify as direct evidence. I'm serious. Can you believe they actually try this stuff? They do it all the time. Number 5, the accusation must be made under penalty of perjury. If perjury cannot reach the accuser, there is no accusation. Otherwise, anyone may accuse another falsely without risk. Absolutely. An indictment or an accusation under a penalty of perjury. Element number 6. To comply with the 5 elements above, that is for the accusation to be valid, the accused must be accorded due process. They always deny due process. Accuser must have complied with the law, procedure, and form in bringing the charge. This includes court-determined probable cause, summons and notice procedure. If a lawful process may be abrogated in placing a citizen in jeopardy, then any means may be utilized to deprive a man of his freedom, and all dissent may be stifled by utilization of defective process. Element number 6. The essential elements of due process are notice and an opportunity to defend. One is not entitled to protection unless he has reasonable cause of apprehend danger from a direct answer. The mere assertion of a privilege does not immunize him. The court must determine whether his refusal is justified and may require that he is mistaken in his refusal. So again, due process. Essential elements of due process are notice and opportunity to defend. And element number 7, the court must be one of competent jurisdiction. If the judge is a bought and paid for clerk masquerading as a judge, they're not in good behavior. They're in bad behavior. It's not a court. To have valid process, the tribunal must be a creature of its constitution in accordance with the laws of its creation. An Article 3 judge. There is no such thing as an Article 3 judge. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit. Don't forget to like this video on YouTube. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. This is the front page of my channel. The subscribe button's already been clicked. The bell has not been clicked because it doesn't look like it's vibrating. The arrow is pointing at the bell. So if you want to be notified of new uploads, you got to click that bell. When you're challenging jurisdiction, okay, impropriety persona, in one's own proper person, it is a rule in pleading that pleas to jurisdiction of the court must be pled in propriety persona, because if pleaded by an attorney, they admit the jurisdiction. As an attorney is an officer of the court, and he is presumed to plead after having obtained leave, which admits the jurisdiction. So you cannot challenge jurisdiction through a liar. It's impossible. And that's why they want to assault you with their liars, because then it's a star chamber. The corrupt Star Chamber courts of England required defendants to have counsel. Star Chamber stood for swiftness and arbitrary power, and it was a limitation on the common law. Okay, and that's U.S. Supreme Court case, Beretta versus California. They love to assault you with their liars. So the first thing you ask them is this a Star Chamber then? You're assaulting me with your Star Chamber? State statutes are actually national statutes. In the sense of public international law, the several states of the Union are neither foreign to the United States nor are they foreign to each other. But such is not the case in the field of private international law. That's why they pass the Uniform Commercial Code in every state, because that's private international law, and they assault you with their Uniform Commercial Code. The United States government is a foreign corporation with respect to a state of the Union. Downs versus Bidwell. Municipal corporations, okay, that's what they're always assaulting you with, is with their municipal corporation. This is D.C. Fifth, the Constitutional has undoubtedly conferred on Congress the right to create such municipal organizations as it may deem best for all the territories of the United States, okay? That's exactly what it is this territorialism. They're assaulting you with their municipal corporation. There's 2 states in every state. There's been created a fictional federal state of XXX within a state, and 2 national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And that's again Downs versus Bidwell. And there it is, Indiana and Company. 3,460,000 stockholders engaged in providing peace, justice, security, opportunity, health, highways, education, conservation, recreation. Certificate. Every Indiana citizen is a stockholder. to 4,300 schools. Boy, that's hard to read. Oh, there we go. That's better. 4,300 schools. Looks like 9,460 miles of highways. 4,300 school buildings, I guess. 34 state parks and memorials. 12 state institutions, 4 colleges and universities, state library, state fair. This certifies that every Indiana citizen is the owner of a full share of the common stock of Indiana and Company. Some of that stuff is hard to read. Report for the fiscal year beginning July 1st, 1936 and ending June 30th, 1937, prepared by the Indiana Gross Income Tax Division. Clarence A. Jackson, Director, Indiana Department of Treasury Board. M. Clifford Townsend, Governor. Peter F. Hine, Treasurer. Do you think it's still that case today? I'll bet you it's been bankrupt and it's now owned and operated by some banksters. There's 2 states in every state. The Judiciary Courts of the State of Texas is a subsidiary of the State of Texas, as found in the affidavit of Daniel Lee Swank, which is recorded in the Liberty County Recorder at recording number 2008-010522, which has attached a Dun & Bradstreet listing for the Judiciary Courts of the State of Texas. Year started 1845, headquartered location Supreme Court Building, Austin, Texas. 78701, top executive Thomas R. Phillips, Chief Justice, business type corporation, profit. On page 2 it shows, as noted, this company is a subsidiary of Texas State of Inc. State court system, which includes the Supreme Court, Court of Criminal Appeals, courts of last resort, 14 courts of appeals with 80 judges, district court with 386 judges, criminal district court with 10 judges, and county level court with 445 judges. And there's the filing. So this is the front page of the recording. So let's go to the attachments. Oh, look at that. Judiciary Courts of the State of Texas, a Dun & Bradstreet D&B Business Background Report. Subsidiary of Texas State of Austin. Supreme Court Building, the headquarters. Year started 1845. That's the year that Texas joined the Union. This is the headquarters location. Industry. Line of business. State court system. And then down here where it says business type corporation for profit. Date incorporated 1836. That's when Texas gained independence. I guess 00001836. How do you do that? I never heard of a 00001836. Oh, let's get it in closer. Judiciary Courts of the State of Texas, subsidiary of Texas State of. Year started 1845. Supreme Court Building. Industry, state court system, corporation for profit. 00001836. How does that work? And then this is the second page. As noted, this company is a subsidiary of Texas State of Inc. State court system, which includes the Supreme Court, Court of Criminal Appeals, courts of last resort, 14 courts of appeals with 80 judges, district court with 386 judges, criminal district court with 10 judges, and county level courts with 445 judges. Branches, the department maintains 4 courts of appeals, 375 district level courts, and 420 county level courts. This is the official records of Liberty County, and there's a notarized statement saying that it's a certified copy, I guess. My contact information is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile is Sovereign Living. My Facebook community page is deleted. My private group, Sovereignty International, is being deleted. That's on Facebook. Matter of fact, I haven't been there in months. Facebook's a has-been. My Yahoo private group, Administrating-Your-Public-Servants. My Google private group is called Administrating-Your-Public-Servants. Follow me on Twitter at EngineerWin. Follow me on Steemit at Sovereignty International. I got a BitChute profile, and I also have a Patreon channel. Texas territory in this state means within the exterior limits and includes all territory within these limits ceded to or owned by the United States. And so then in this state is only all territory within these limits ceded to or owned by the United States, because includes is limiting. And here's some court cases that talk about includes. This is Montello Salt versus Utah, U.S. Supreme Court. Include, or the participial form thereof, is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve. Include is, and again, there's American Dictionary of the English Language, and there's Black's Law Dictionary, 6th edition. Okay, so includes is limiting. The owner of a motor vehicle registered in this state, that means in federal areas of Texas. A person may not operate a motor vehicle registered in this state, that means federal areas of Texas. Owner of a motor vehicle that's required to be titled and registered in this state, in that's federal areas of Texas. That's all in the Texas Transportation Code. A person other than a person expressly exempted under this chapter may not operate a motor vehicle on a highway in this state. That's Texas Transportation Code. A person may not operate a motor vehicle in this state unless financial responsibility. A motor vehicle, trailer, semi-trailer, pole trailer, mobile home registered in this state. Okay, so it's all federal areas of Texas. Municipal court of record is federal in this state. That's Texas territory. Assisting prosecuting attorney must be licensed to practice law in this state. Texas territory. Judges are all in this state. Texas territory. Board of Law Examiners practicing laws in this state, federal territory. Again, in this state, it's all Texas territory. Texas Tax Code in this state. Law Enforcement Agency in this state. Texas Code of Criminal Procedure, a warrant of arrest in this state. That's federal areas. In this state, Texas Code of Criminal Procedure. States or territories. U.S. Code Title IV, Flag and Seal, Seat of Government, and the states. Okay? The states is Chapter 4. Territorial states. The states are territories. Oath by members of the legislatures and officers. Okay? Again, they're all territories. The federal government tells them how to do everything. That's in this state. That's because of the military occupation. Downs versus Bidwell. Eliminating then from the opinions of this court all expressions unnecessary to the disposition of the particular case, and gleaning therefrom the exact point decided in each, the following propositions may be considered as established. Number 3, that the District of Columbia and the territories are states, as that used as word in treaties with foreign powers with respect to the ownership, disposition, and inheritance of property. And that's talking about the Sestake Trust. And it was soon after that, this is 1901, it was soon after that they started talking about administration, the Trump administration. I have exclusive content available on my website and on Patreon. My website has 2 subscription levels, and I accept cryptocurrencies. The Patreon has actually 3 subscription levels. On the $29.99 a year on my website is for the videos only. $49.99 a year is for the videos plus unlimited consultations. Now, my unlimited consultations do have limits, because I'm not a liar. Well, I meant an attorney. No, I meant a liar. But I can tell you what I would do and where to find the forms. Now, Yahoo has been taken down. They took down their files directory, and so now I guess I'll just have to email you the forms. The forms, there's a lot of forms available on my website now. That's sovereigntyinternational.fyi, and if you go there on the front page, there's a link to forms and documents. Okay, so I had a bunch of forms uploaded there, and so a lot of them are available there. So I would suggest you go there first, and if you can't find them, then I'll email them to you. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. I need other people being on point. And so if you want to make a donation or buy a subscription just as a donation, it's a modest donation, there's no doubt, but a whole bunch of people chipping in a little bit adds up pretty fast, and so it's all appreciated. I'm currently publishing a video a week. I have some of the content, the exclusive content and the Patreon content is the Arlington Private Information Share, Land Deed Training, Estoppel Certificates Training, Foreclosure Estoppel Certificates Training, Corporate Denial Training, Toll Roads Notice and Demand Training, Invoice Training, Notice of Void Judgment Training, Revocation of Signature Training, Third Party Witness Training, Federal Habeas Corpus Training, Revocation of Voter Registration Training, Criminal Complaint Training. There's actually about 3 videos on that, and there'll be more. Lawsuit training, I've got 1 video on that, and there'll be more. Other training requests, depending on what, if you're missing something or need something, you know, it might be something I can do, it might not, you know, so, but you can toss it out there and see. My Northeast Private Information Share videos are up there. All forms, files, and other instructions are available for free on my 2 private groups, the Yahoo groups and Google groups, and now on my website. And so the exclusive content's available on my website, and you can buy a subscription there or on Patreon. Yeah, on Patreon, there it is, Sovereignty International. The territories, all hospitals and healthcare, which is really death care, that's all territorial. All financial institutions is territorial. All labor organizations, all law enforcement agencies, all government agencies, courts, cities, counties, municipal corporations, etc. All taxes. It's all national. The officers of their court are U.S. citizens. They're demanding Federal Reserve notes. Matter of fact, there's a guy that I know that does that jurisdiction conference call, and he tells them, look, you know, you got to tell me what this number means. I'll pay you whatever you want. I want to pay it. You know, you tell me what to pay you. And they won't come out and tell you. Matter of fact, what he did one time is he said, will you take what they take down at Albertsons? And they'll say, oh yeah, we'll take that. And so he went down there and he got a bunch of coupons, and he brought the coupons back and he gave them to the judge, and the judge didn't, that was it. And he had to accept it because he said, and if you go there on Wednesdays, you can get 4 times. Because on Wednesdays they get 4 times coupons, right? All of their LEOs, court enforcers, are U.S. citizens. They're demanding Federal Reserve notes, okay? This is all national. As used in this act, the term United States means the government of the United States. The term currency of the United States means currency which is legal tender in the United States and includes the United States notes and Federal Reserve notes. So again, the Federal Reserve notes are meant for internal use of the government only. That's Gold Reserve Act of 1934. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt. Okay, and so that's U.S. Supreme Court again. And so again, the forced loans, okay, they were vital forces in the struggle for national supremacy. So again, if you use Federal Reserve notes, this is presumptions. My next video is going to be on presumptions, and this gives them the right to presume that you're one of the slaves. You're a government employee, and you're subject to all these code rules and regulations. Capitis diminutio, meaning the diminishing of status through the use of capitalization. In Roman law, this is all Roman law they're assaulting you with. Okay, this is all coming from the Roman cult. A diminishing or abridgment of personality, a loss or curtailment of a man's status or aggregate of legal attributes and qualifications. Capitis diminutio maxima, meaning a maximum loss of status through the use of capitalization. the highest or most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away with it all rights of citizenship and all family rights. U.S. citizens are enemies of the state. All persons born or naturalized, okay? And that's in the federal territory, okay? And so if you're not born in federal territory, then you're not a U.S. citizen. But it's all what you tell them. You must be born in federal territory. Merely being native born within the territorial boundaries of the United States of America does not make such an inhabitant a citizen of the United States subject to the jurisdiction of the 14th Amendment. And in the same case, it goes on, the persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these lands words is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject. We can't even begin to count the times and the numbers of times judges, lawyers, and statesmen said there isn't any common law anymore. It's been replaced by statutes. They would be more truthful if they said there isn't any common law anymore. It's been replaced by martial law. And that's taken from the non-ratification of the 14th Amendment by Judge A.H. Ellett to the Utah Supreme Court in the case Diet versus Turner. And another cite. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law, to have superior equities to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. The exclusive jurisdiction of the United States, having forts and dockyards ceded to them, is derived from the express assent of the states by whom the cessions were made. It could be derived in no other manner, because without it the authority of the state would be supreme and exclusive therein. Again, that was 1818, before the Civil War. It's well-established principle of law that all federal regulation applies only within the territorial jurisdiction of the United States, okay? Again, territorial jurisdiction, okay? Are you in the territory? There is a canon of legislative construction that teaches Congress that unless a contrary intent appears, legislation is meant to apply only within the territorial jurisdiction of the United States, okay? Again, that's D.C. and the territories, folks. The United States is located in the District of Columbia. That's Uniform Commercial Code, Section 9.307, location of debtor. If a citizen acquires the same legal status as those protected by the amendment through the operation of some statutory law of Congress, then said citizen may be brought within the venue of the amendment as a statutory juristic person. By this means, citizens' birthrights become of no effect, and their rights are reduced to the inferior character of statutory civil rights, which are mere legislative privileges. Check out my other videos, my Bankster Thieves playlist, my Roman Cult playlist, my Bankrupt Corporate So-Called Governments, bar members 1 through 6 now, I think, 5 anyways. Do it yourself, how not to volunteer for the selective service and draft, martial laws here, do it yourself, no income tax, do it yourself, free mail, do it yourself, Kangaroo Courts 1 through 16 now. Canada Border Pigs playlist, bar members and their Satanic Connections playlist. There's 2 classes of citizens. You can be a state citizen or a free inhabitant, or a federal citizen. You can be a state citizen without being a U.S. citizen. Watch the Do You Know Who You Are video. A U.S. citizen is not entitled to an Article 3 court, but instead gets an Article 1 court with a plenary military dictatorship jurisdiction, and Article 1, Section 8, Clause 17, Constitution for the United States of America, as defined and reinstated in National Mutual Insurance Company, the District of Columbia, versus Tidewater Transfer Company, which further states that citizens of the District of Columbia are not embraced in the judicial power under Article 3 of the Constitution of the United States of America. The same statement is held in Hepburn versus Dundas. In 1804, the Supreme Court, through Chief Justice Marshall, held that a citizen of the District of Columbia is not a citizen of a state. We therefore decline to overrule the opinion of Chief Justice Marshall, we hold that District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress can give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington, District of Columbia, and through their plenary power, that's military dictatorship, folks, nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. If any citizen or resident of the United States does not reside in and is not found in any of the United States Judicial District, such citizen or resident shall be treated as residing in the District of Columbia for the purposes of any provision of this title to A, jurisdiction of the courts, or B, enforcement of the summons. And that's where it's codified, folks. The term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. And the term federal personnel means officers and employees of the government of the United States, members of the uniformed services, including members of the reserve components, and individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. Okay, so that means anybody with a Social Security number is federal personnel, folks. And that's found at Title 5, United States Code, Section 552 AA 13. Well, gee, that sounds like that's government employees, government organization and employees. The term citizen of the United States is analogous to the term subject in the common law. So this is all about jurisdiction. And when you start bringing this stuff up and you go through and explain it, and it causes big time problems. Because they're presuming that you're one of the slaves. Okay, it's all on presumption. And the next video is going to be on presumptions. And so you have to defeat their presumptions. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country, being bound to the society by reason of their dwelling in it. They're subject to its laws so long as they remain there, and being protected by it, they must defend it, although they do not enjoy all rights of citizens. They have only certain privileges which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They are a sort of citizen of a less privileged character and are subject to the society without enjoying all its advantages. Their children succeed to their status, for the right of perpetual residence given them by the state passes to their children. Permanent residents. The Law of Nations, this is taken from the Law of Nations by Vattel, Book 1, Chapter 19, Section 213, page 87. So unless, really, at the end of the day, unless you can show that your ancestors were here when the Declaration of Independence was signed, then it's a problem. Actually, Civil War. If your ancestors were here prior to the Civil War, then it's by blood, okay, by right of blood, and that's a problem for them. Every taxpayer is assessed to a trust having sufficient interest in preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. That's a summary of Henry Boland's. And another summary of 5 pages of congressional record. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust, the constructive cesticate trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And this is the D.C. Code, which is now called United States Code. Chapter 854, an act to establish a code of law for the District of Columbia. It was approved on March 3rd, 1901. Notice it was just after that Downs versus Bidwell case. By the 56th Congress, Session 2, 31 Stat 1189. In addition to the jurisdiction conferred in the preceding section, plenary jurisdiction is hereby given to the said court holding the said special term to hear and determine all questions relative to the execution of any and all wills, and the legal estate to be the cesticate use. So if you're in the District of Columbia, remember we're talking about the district, the boundaries of the District of Columbia expands as necessary. That's an old court case. And it goes on. And be it further enacted that interpretation and construction of said code, the following rules shall be observed, namely the word person. Third, the word person shall be held to apply to partnerships and corporations. And fourth, the word executor shall include administrator and vice versa, unless such application of the term would be unreasonable. And so again, those are all terminologies that you can use, and that causes some problems, especially administrator, administration. U.S. citizens, a government employee, or a cesticate trust. Now, there's some stuff that there's in the U.S. I mean, to say the Civil War was about race, although they're certainly open to debate about that. The bottom line, though, is that racism is satanic, in my opinion, and it's a satanic doctrine of divide and conquer. The Roman cult has been planning this stuff for centuries. They're enslaving everybody, no matter what race you are, because of this. Why do you think they have their policies about racial profiling? It's because they want to be able to enslave everybody. If you're white and you think you're treated better, then think again. 13th, 14th, and 15th Amendments were designed mainly for the protection of newly emancipated Negroes. Okay, remember what that Utah Supreme Court said, that there's inferior statutory civil rights. The 14th Amendment referred to slavery. Consequently, the only persons embraced by its provisions for which Congress was authorized to legislate in this manner were those then in slavery. No white person born within the limits of the United States and subject to their jurisdiction, or born without those limits and subsequently naturalized, owes his status of citizenship to the recent amendments to the federal Constitution. All citizens, this is current law. All citizens of the United States shall have the same right in every state and territory as enjoyed by white citizens thereof, to inherit, purchase, lease, sell, hold, and convey real and personal property. That's current law, 42 U.S.C. 1982. The only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States. If you're a U.S. citizen, then you're a slave. And this is again Judge A.H. Ella of the Utah Supreme Court in the case Diet versus Turner. In other words, when state martial law is imposed within the state to enforce national martial law, Congress has no reason to exercise its martial law powers. If a state has conformed to the new order, there is no need for Congress to intervene. And if a white citizen has not obtained the standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, then Congress has no power over that individual. It's all voluntary. Okay, again, that's all about jurisdiction, the 7 elements of jurisdiction. You start bringing this stuff up, and you're causing them big time problems. And I can tell you that I've had 2 cases disappear. I've only used it 2 or 3 times so far, actually 4 times, and I haven't heard on the other 2 cases. But I expect that they'll disappear too, or they'll get dropped. But I'm going to file lawsuits anyways. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as voluntary subscription to a license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Matter of fact, I'm gonna file. I think I can. It's felonies. They're involved in felonies. This has been going on from the beginning of time. This is taken from the Causes and Necessities for Taking Up Arms in 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial. Okay, so martial law supersedes and replaces common law. That's what they want to do. Okay, at common law, they'd all be put to death for doing this stuff. This is Declaration of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation. That's color of law. For imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury. It's all martial law. And get a load of this. George III, Chapter 12, 1778, 2 years after the Declaration of Independence. This is passed by the Imperial Parliament in England. Whereas taxation by the Parliament of Great Britain for the purpose of raising a revenue in His Majesty's colonies, provinces, and plantations in North America have been found by experience to occasion great uneasiness and disorders. Well, no shit, Batman! That from and after the passing of this act, the King and Parliament of Great Britain will not impose any duty, tax, or assessment whatever payable in any of the colonies, provinces, or plantations in North America, except only such duties as may be expedient to impose for the regulation of commerce. So the root of the problem is the martial law. The martial law rule brings in Roman civil law and displaces the law of the land. See the martial laws here video. Martial law is brought in by the bankruptcy. See bankrupt corporate so-called governments video. Bankster 1s, Bankster 2s, Bankster 3s videos. De facto courts, Unidroit videos. The United Nations is the source of it all. Under Roman civil law, status is everything. Under common law, status is nothing. And it's all Satanism. They're getting you into one of their so-called contracts, and it's literally a contract with the devil. Satanic martial law works on presumption. They presume you're in a contract and go ahead and assault you, okay? And then my next video is going to be on presumption. If you want any rights, you have to go before one of their bail priests so they can assault you again with their equity and their Roman law. They deliberately screen out intelligent people in the hiring process so they can make more business for their bail priests and their so-called courts. The District of Columbia should be called the District of Criminals. Give me liberty or give me death was coined by Patrick Henry after he witnessed a man flogged to death for refusing to take a license. So the Satanists were shoving one of their satanic contracts down somebody's throat. A license is a contract, is a right given by competent authority to do an act without which such authority would be illegal. The instrument of writing which secures this right is also called a license. The most important thing we can do is to stop letting these Satanists divide us so they can conquer us. Most of these satanic statutes are for people who cannot voluntarily respect other people or their property. Our Constitution was made only for moral and religious people, is wholly inadequate to the government of any other. John Adams, men, in a word, must necessarily be controlled either by a power within them or by a power without them, either by the word of God or by the strong arm of man, either by the Bible or by the bayonet. And that's John Winthrop, Speaker of the U.S. House. So never give up, right? That's what you got to do, is never give up. War is when your government tells you who the enemy is. Revolution is when you figure it out for yourself. The rights of sovereignty extend to all persons and things not privileged. You got to stay away from their privileges. They extend to all strangers resident therein, not only to those who are naturalized, but to those who are domiciled therein, having taken up their abode with the intention of permanent residence, but also to those whose residence is transitory. All strangers are under protection of the sovereign while they're within his territory and owe a temporary allegiance in return for that protection. That's all words that are taken from the Bible, from the Old Testament. Read Deuteronomy and Exodus. They're assaulting you with their Federal Tax Lien Act. A motor vehicle is the term means a self-propelled vehicle which is registered for highway use. Okay, so when you get that registration plate, they can presume that you have a motor vehicle. And that's taken from the Federal Tax Lien Act of 1966 at Public Law 89-719 and 80 Stat 1130 and 1131. The two biggest privileges are Federal Reserve notes and government-owned plates. And the privilege replacements would be cryptocurrencies and private plates. And I like the Texas plates they can use anywhere because all states, Canada and Mexico included, are required to recognize Texas law. This is Texas Transportation Code 501.004. This chapter applies to motor vehicle owned by the state or a political subdivision of the state. So again, that's the Certificate of Title Act. It only applies to government-owned vehicles. And I like the Texas plates because they can be used anywhere in Canada and Mexico because they're required to recognize Texas law. Texas Transportation Code 502.003, registration. Remember, when they charge you with something, it's got to separate you from anything that you might be protected or following under, which is, and this one says that they can't require you to register a motor vehicle. And a political subdivision of this state may not require an owner of a motor vehicle to register the vehicle, pay a motor vehicle registration fee, or pay an occupation tax or license fee in connection with the motor vehicle. And under the Articles of Confederation, Article 4, Clause 3, the full faith and credit shall be given in each of the states to the records, acts, and judicial proceedings of the courts and magistrates of every other state. So they have to recognize, so that's why when you can travel as with Texas plates in every other state. And there is these laminated or Texas private plates. These are ones that I've had made up, and you can make your own up too if you want, but the important thing is to have your own private plate. Don't have one of the state plates. And there's another one, and this is all Texas colors, okay? Blue and yellow are Texas colors. There's another one. This is the one, actually a similar one to this that I use. And this is another one. I send out thousands of notice and demands with copies of these plates on them to government officials. You can get one plate and one probable cause lamination for 3 pieces of silver, 1 troy ounce each, or $50 in military script, Federal Reserve notes, or fake money. Before you do this, you need to be prepared to defend it, and that's why the card in my car, because the discussion should end right there when I show them that nobody's required to register the vehicle. My PayPal address is engineerwin@hotmail.com, and you can get the Forbidden Zone laminated sheets from catman1@gmail.com. Before any police officers stop you, okay, they must have probable cause, okay? And of course, this is in Texas, because well, anywhere, okay, they got to have probable cause that there's a crime, okay? And just if they're stopping you for that plate, okay, then that's a felony. We're going to get into that. Again, it comes down to the elements of jurisdiction, and you go through, and if you want that document, send me an email. I'll send it to you. Article 4 of the amendment prohibits law enforcement officers from arresting citizens without probable cause. An arrest made without probable cause violates the 4th Amendment. Holding involuntary civil confinement is a massive curtailment of liberty. It is tantamount to the infringement of being arrested and can be made only upon probable cause. So, what's probable cause? And this is all in this laminated sheet that I made up. The test for a police officer's sufficient basis for probable cause is, did the officer have a sufficient basis to make a practical, common sense decision that a fair probability of crime existed? Once the officer's actions fail to satisfy this test, it may appear that no reasonably objective officer could have believed that probable cause existed to make an arrest. And by definition, probable cause to arrest can only exist in relation to criminal conduct. Civil disputes cannot give rise to probable cause. So, if it's not a crime, then they don't have probable cause. And this is again the other side of the laminated sheet. Perhaps it should be mentioned that as a general rule, a person is placed under arrest when he's deprived of his liberty by an officer who intends to arrest him. So if they stop you, then it's an arrest. I don't care what they want to call it. Any restraint, however slight, upon another's liberty to come and go as one pleases constitutes an arrest. If they like to call it, you're just being detained. Well, it's an arrest, buddy. Texas Penal Code, bail jumping and failure to appear. An offense under this section is a Class C misdemeanor if the offense for which the actor's appearance is required is punishable by fine only. Conviction of a Class C misdemeanor does not impose any legal disability or disadvantages. A individual judged guilty of a Class C misdemeanor shall be punished by fine only, not to exceed $500. Okay, so again, a Class C misdemeanor is punishable by fine only. Well, under Texas Government Code 79.001, crime means a misdemeanor punishable by jail or a felony. Okay, so a Class C misdemeanor is not a crime. If a Class C misdemeanor fails to be a crime, then it's by definition a civil matter. If the owner of a motor vehicle fails to timely pay the amount of the civil penalty imposed against the owner, an arrest warrant may not be issued for the owner, and the imposition of the civil penalty may not be recorded on the owner's driving record. That's Texas Transportation Code 707.019. In Texas, the police may not arrest you for a Class C misdemeanor, and if they do, it's false arrest. The only thing the plaintiff needs to do is allege a false arrest, is either that the defendant made an arrest or imprisonment, or that the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. When the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. The burden is upon the defendant to show that the arrest was made by authority of law. If it's a Class C misdemeanor, it's false arrest. If the owner of a motor vehicle fails to timely pay the amount of the civil penalty imposed against the owner, an arrest warrant may not be issued for the owner. The imposition of a civil penalty may not be recorded. And a capias is not a warrant of arrest. That's what they like to do, is a capias. In this chapter, a capias means a writ that is issued by a court having jurisdiction of a case after judgment and sentence. And a capias pro fine means a writ that's issued by a court having jurisdiction after judgment and sentence. And a capias is not a warrant. If a cop stopped me for speeding in Texas, I would say I don't have a problem providing whatever you need, but I got a couple questions for first. What's your probable cause for stopping me? And if you stop me for speeding, you'll say that, and I'll say, well, speeding's a Class C misdemeanor, and a Class C misdemeanor is not a crime in Texas, and probable cause requires a crime. So I ask you again, what's your probable cause for stopping me, or should I just be on my way? Then I'd dial 911 and tell them I need the county sheriff there because there's some official oppression going on. And abuse of official capacity. A public servant commits an offense. This is all in Texas, of course. Okay, so these statutes are not going to apply in other states. The only ones that would apply is the ones that you're using for justification to have your private plate on your vehicle. They'll have to recognize that elsewhere. But other than that, these crimes, they will not recognize elsewhere. You can probably look up in your local codes equivalents. Anyways, this is Texas Penal Code, abuse of official capacity. A public servant commits an offense if with intent to obtain a benefit or with intent to harm or defraud another, he intentionally or knowingly misuses government property, services, personnel, or any other thing of value belong to the government that has come into the public servant's custody or possession by virtue of public servant's office or employment. So, if he turns on his emergency light when there's no emergency, when there's no crime, okay, if there's no crime, he shouldn't be turning his emergency light on, and that's abuse of his official capacity, turning on his emergency light. If he's calling on the radio, he's using the government property to generate revenue when there's no crime. A person commits an offense. This is failure to identify. A person commits an offense if he intentionally refuses to give his name, residence, or date of birth to a peace officer who has lawfully arrested the person and requested the information. Okay, and the operative word here is lawfully arrested and a peace officer. If the officer is stopped you for speeding, then there's no lawful arrest, and he's not a peace officer, he's a revenue officer. Texas Penal Code, official oppression. A public servant acting under color of his office or employment commits an offense if he intentionally subjects another to mistreatment or to arrest, detention, search, seizure, dispossession, or a lien known that is unlawful, intentionally denies or impedes another in exercise and enjoyment of any right, privilege, power, immunity, knowing his conduct to be unlawful, or for purposes of this section, a public servant acts under color of his office or employment if he acts or purports to act in official capacity or takes advantage of such actual or purported capacity. So that's official oppression, and that's exactly what these pigs are doing. Impersonating a public servant. A person commits an offense if he impersonates a public servant with intents to do it as another, to submit to his pretended official authority, or rely on his pretended official acts. Knowingly purports to exercise any function of a public servant or public office, including that of a judge in court, and the position or office through which he purports to exercise a function of a public servant or public office has no lawful existence under the constitutional laws of the state or the United States. And so this is a felony of the third degree. These judges, now when they go and when they're operating for state of Texas, remember you got to watch my video about state of Texas doesn't exist, because the state of Texas is actually a assumed name for Deer Park Cash Cow LLC. And so if this judge is operating for state of Texas and issuing orders, then that's exactly what he's doing, is he's exercising a function of a public servant or public office has no lawful existence under the constitutional laws of the state. And he's impersonating a public servant. That's a felony. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, or district in the free exercise and enjoyment of any right or privilege secured to him by the constitutional laws of the United States, or because of his having so exercised the same. Okay, so think about it. It comes down to consumer goods, and we're going to talk about that in a minute. But well, then we'll talk about it. Okay, so remember, this is conspiracies under 18 U.S.C. 241. And 18 U.S.C. 242 is violating rights under the color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any inhabitant of any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the constitutional laws of the United States shall be fined under this title or imprisoned. So, okay, so 18 U.S.C. 242 is violating your rights under the color of law. And 18 U.S.C. 247 is obstruction of persons in the free exercise of religious beliefs. Whoever, in any circumstances referred to in subsection B of this section, intentionally obstructs by force or threat of force, including by threat of force against religious real property, any person in enjoyment of that person's free exercise of religious beliefs, or attempts to do so. Okay, so again, if they're assaulting you with their satanic religious ceremony, then that's a violation, 18 U.S.C. 247. And so they like to claim good faith. And this is 18 U.S.C. 2707. A good faith reliance on a court warrant or order, a grand jury subpoena, a legislative authorization, or statutory authorization, including a request of a governmental entity under Section 2703 of this title, a request of an investigative or law enforcement officer under Section 2518 of this title, or a good faith determination that 2511.3 of this title permitted the conduct complained of, is a complete defense to any civil or criminal action brought under this chapter or any other law. And that's why they're taking so long building a case against these Obama criminals, because that's exactly, they're saying, well, I had a good faith belief that what I was doing is the right thing. And this is Texas Codes. No evidence obtained by an officer or other person in violation of any provisions of the constitutional laws of the state of Texas or the constitutional laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. It is an exception to the provisions of subsection A of this article that the evidence was obtained by a law enforcement officer acting in objective good faith reliance upon a warrant issued by a neutral magistrate based on probable cause. Well, they're not neutral. They're bought and paid for. Don't get me going. So, but that's what they're going to claim. They're going to claim it's, oh, I had good faith. Government officials are required to know the law. Government officials are required to know that a warrant may not be issued, and a capias may only be issued after they get a jurisdiction, hold a trial, and a conviction. Any denials of due process or bad behavior, they always deny due process in countless ways. That's why you build a case against them by telling them they don't have jurisdiction, the 7 elements of jurisdiction. That's why I recommend you have one of my Kangaroo Court Survival laminated sheets with you in their so-called court. And bad behavior. Okay, the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish. The judges both of the Supreme and inferior court shall hold their offices during good behavior and shall at stated times receive for their services a compensation. So they only hold office during good behavior. And that's important to keep that in mind, because if he is in bad behavior, he's not a judge. And this is the laminated sheet. Fraud upon the court is fraud that's directed to the judicial machinery itself. It is not fraud between the parties or fraudulent documents, false statements, or perjury. It's where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function. In other words, where the impartial functions of the court have been directly corrupted. And that's the other side of the Kangaroo Court laminated sheet. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. Jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. Once challenged jurisdiction cannot be assumed, it must be proved to exist. There is no discretion to ignore lack of jurisdiction. Where jurisdiction is contested, the burden of establishing it rests upon the plaintiff. The burden of proving jurisdiction rests upon the party asserting it. Court must prove on the record all jurisdiction facts related to the jurisdiction asserted. However late this objection to jurisdiction has been made, or may be made in any cause in an inferior or appellate court before the United States, it must be considered and decided before any court can move one further step in the cause, as any movement is necessarily the exercise of jurisdiction. The court has no jurisdiction to determine its own jurisdiction for a basic issue in any case before a tribunal is its power to act, and a court must have authority to decide that question in the first instance. The departure by a court from those recognized and established requirements of law, however close apparent adherence to mere form and methods of procedure, which has the effect of depriving one of a constitutional right, is an excess of jurisdiction. The burden shifts to the court to prove jurisdiction. The fact that the petitioner was released on a promise to appear before a magistrate for an arraignment, that fact is circumstance to be considered in determining whether in the first instance there was a probable cause for the arrest. It is impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to license. All jurisdiction facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Okay, so again, if they stop you for a Class C misdemeanor in Texas, then they didn't have jurisdiction in the first place. When liberty and freedom are at stake, your silence isn't golden, it's yellow. Where a court failed to observe safeguards, it amounts to a denial of due process. The court is deprived of juris. Not every action by any judge is an exercise of judicial function. It's not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of law, when the judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void and of no legal force or effect. If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action, and that's Federal Rules of Civil Procedure. Defense of lack of jurisdiction over the subject matter may be raised at any time, even on appeal. Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term. A county attorney shall represent the state in all cases in the district and inferior courts in their respective counties. Although probable cause may not be inferred from malice, malice may be inferred from the lack of probable cause. In other words, if that low intelligence hired thug stops you for a Class C misdemeanor, then he didn't have probable cause to stop you. Okay, and if he goes and gives you a ticket, then that ticket is a malicious prosecution. Think about it. That's exactly, and this court case will support that. A universal principle as old as the law is that the proceedings of a court without jurisdiction are a nullity, and its judgment therein without effect either on person or property. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act or acts of treason. A court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. It is clear and well-established law that a void order can be challenged in any court. Where there is no jurisdiction, there is no judge. The proceeding is as nothing, such has been the law from the day of Marshal Saya. Brutum fulmen, an empty noise, an empty threat, a judgment void upon a space which is in legal effect no judgment of all, and by which no rights are divested, and from which none can be obtained, and neither binds nor bars anyone. An officer who acts in violation of the Constitution ceases to represent the government. Judge loses his absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. In arriving at our decision in this matter, we do not depart in any way from our holding in Hundling versus Jensen that the doctrine of judicial immunity extends to courts of limited jurisdiction. But when a minor magistrate acts wholly without jurisdiction, civil liability attaches for his malicious and a corrupt abuse of process and his willful and a malicious oppression of any person on the pretense of acting in his official capacity. A person commits it. This is Texas Penal Code. We already covered this, impersonating a public servant. Change will not come if we wait for some other person or some other time. We are the ones we've been waiting for. We are the change that we seek. So subject matter jurisdiction is the issue. Do not give them jurisdiction. Always make a special appearance. Point out their denials of due process. Do not allow them to enter a plea. It gives them jurisdiction. You're not entering a plea. I don't give you jurisdiction. And if they go ahead and say, I don't care, I'm entering it anyways, then here's my notice of appeal right now. And have a notice of appeal ready to go. You have already demonstrated that you prejudged this matter as a bought and paid for clerk working for the prosecutor, so we're impersonating a judge today, are we? Demand that it be dismissed immediately. Copies of these documents can be found in my private group at Yahoo and Google called Administrating-Your-Public-Servants. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries, and other books and forums, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the IOUs, the Federal Reserve notes, the PayPal gifts, the checks, the money orders, etc. Send me an email for particulars. And so this is all about Uniform Commercial Code, okay, which is private international law. It's UNIDROIT. All municipal corporations, all courts, it was previously called the conflict of laws. So are you subjecting me to the deprivation of my right to own consumer goods instead of business equipment under color of law? Okay, and this is, again, we were talking about this earlier, 18 U.S.C. 242, violating rights under color of law. And so that's what you ask, if they're going to assault you for having that private plate on there. Are you subjecting me to the deprivation of my right to own consumer goods instead of business equipment under color of law? Because that's a felony under Title 18, United States Code, Section 242. And so then, and this is under 241, it's a conspiracy to violate rights under the color of law. So are you threatening me? You're threatening me, so just so I understand what's going on here, you intend to threaten me, oppress me, intimidate me, and injure me in the free exercise of my right to own consumer goods instead of business equipment. Is that correct? There, Mr. Judge, is that correct? Do we understand here? And so then under the Uniform Commercial Code 9-109, classification of goods. This is all international law, by the way. But that's what remember, they're all territorial, so they're all operating in international law. Goods or consumer goods that they're used or bought for use primarily for personal, family, or household purposes, and equipment that they're used or bought for use primarily in business, including farming or a profession, or by a debtor who's non-profit organization or a government subdivision. Okay, so again, if it's used, it's either consumer goods or business equipment. Under UCC 9-109, there's a real distinction between goods purchased for personal use and those purchased for business use. The two are mutually exclusive, and the principle to which the property is put should be considered as determinative. The classification of goods on UCC 9-109 are mutually exclusive, okay? And so it's either one or the other. It cannot be both. Automobile purchased for the purpose of transporting buyer to and from his place of employment was consumer goods as defined by UCC 9-109. Thus, self-driving vehicles are classified according to the use to which they are put rather than according to the means by which they are propelled. The provisions of UCC 2-316 of Maryland UCC do not apply to sales of consumer goods, a term that includes automobiles, whether new or used, that are bought primarily for personal, family, or household use. The Supreme Court in Arthur v. Morgan held that carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. A soldier's personal automobile is part of his household goods, and so again, consumer goods. The exemptions provided for in Section 1 of the Motor Vehicle Transportation Act of 1925 in favor of those who solely transport their own property or employees or both, or of those who transport no persons or property for hire or compensation by motor vehicle had been determined in the Bacon Service Corporation to be lawful exemptions. So a company could actually have a bus that is used to carry company employees, and that would still be considered consumer goods because it's a company. It's not used for profit or gain. Consumer goods. Automobile for transportation to and from work. The use of a vehicle by its owner for purposes of traveling to and from his employment is a personal as opposed to a business use, as that term is used in UCC 9-109, and the vehicle will be classified as consumer goods rather than equipment. A vehicle not used for commercial activity is a consumer goods. It's not a type of vehicle required to be registered and use tax paid, of which the tab is evidence of receipt of the tax. So you're not required to register it. So again, am I to understand that you intend to subject me to the deprivation of my right to own consumer goods instead of business equipment? Is that correct? I just want to make this clear. And so you intend to conspire with this pig and this whore and these other people and to threaten, intimidate, coerce, and injure me in the free exercise of my right to have consumer goods instead of business equipment. Is that correct? I just want to understand that. In view of this rule, a statutory provision that the supervising officials may exempt such persons when the transportation is not on a commercial basis means that they must exempt it. It's not mandatory. Consumer goods must be exempt. So all of this stuff is good in every state of the union. The legislature by general law shall exempt from ad valorem. This is the Texas Constitution. This is only good in Texas. But you can find similar stuff in every other state. I found it in Arizona, and you can find it in every other state. The legislature by general law shall exempt from ad valorem taxation household goods not held or used for the production of income, and personal effects not held or used for the production of income. Arizona Constitution, Article 9, Section 2. All household goods owned by the user thereof and used solely for non-commercial purposes shall be exempt from taxation, and such person entitled to such exemption shall not be required to take any affirmative action to receive the benefit of such exemption. And this is the codes in Texas. A political subdivision of this state may not require an owner of a motor vehicle to register the vehicle, pay a motor vehicle registration fee, or pay an occupation tax or license fee in connection with the motor vehicle. They cannot require you to have a driver's license. They cannot require you to pay the tax to register it or to register it. And so again, remember, that comes down to the 7 elements of jurisdiction. And the second one is the statute. Okay, and they can't. If there's a statute that you're covered by, then they're screwed. It is a felony to subject anyone to the deprivation of their right to own consumer goods instead of business equipment. It is a felony to conspire to injure, oppress, threaten, or intimidate anyone in the free exercise of their right to own consumer goods instead of business equipment. Again, that's the argument, folks, and that's how you go after them. And we're going to have to. They obviously, some of them want to go to jail, so let's help them out. Anyways, that's the end of that one. It's all about jurisdiction, the 7 elements of jurisdiction, and you got to use their words. That's what they did with Hillary Clinton. They went and said, well, she wasn't grossly negligent, she was just extremely careless, and they let her get off of committing multiple felonies by doing that. So anyways, it's all about the 7 elements of jurisdiction. You can use this to defeat just about any proceeding. They always deny due process. And so you start pointing it out, and that creates big time problems, and be prepared to appeal it. Here's my notice of appeal. We're appealing it right now. Anyways, thanks for watching. Have a great day. Good luck. And if you need the forums, let me know.